costs. Once the OPC has had a look at an issue, issued a recommendation, and assuming it doesn't get settled, the Director of Proceedings may actually pick the matter up and essentially run your case for you, which is, of course, a handy thing. No one will really do that for you in the employment jurisdiction. So there's another little, as a complainant, another interesting factor to bear in mind. The next bullet point is an interesting and a contentious one in the employment jurisdiction, and that's the level of awards that are granted. Many of us were quite, well, not flabbergasted, but perhaps surprised at the Human Rights Review Tribunal's decision in the Baywide case. Having read that decision and talked about it, you probably wouldn't find a more egregious breach of privacy on a former employer's part. If you want a good, entertaining read, it is worthwhile having a look at. If you can find a picture of the cake involved, even better. Don't share it on your own Facebook page, but if you do. But it's an interesting case, even just through the technical aspect of remedies. When you total up the remedies, they were in the realms of sort of 168k. Now that's, when we think about that from an employment practitioner's perspective, that's high. You know, you would struggle to get that sort of money out of the Employment Relations Authority on a good day. And it's, in some respects, you could argue that it's led to the employment jurisdiction to actually start rethinking its approach to remedies. A couple of years ago, the Employment Court, Judge Ingalls commented in a decision, hey, look, maybe we are getting a bit far behind in the employment world. Maybe we haven't kept up with inflation, social mores, the need to penalise and address inappropriate behaviour. So again, it's interesting. You see people get fixated on large amounts when they're picking jurisdictions, and that can be a dangerous thing when we're advising clients. But the other aspect to bear in mind is that if we have no employment relationship, or the breaches we're concerned about don't arise from an employment relationship, our only jurisdictional option may be either the privacy or the human rights realm. They may be the only way we can go. So when we talk about employment, that's, and pre-employment in particular, it may be an area that leads us in a particular direction. Choices of jurisdiction. When we look at the employment jurisdiction, well, again, the key thing to bear in mind is that as those decisions that I've referred to already, a breach of privacy is not going to be directly actionable as a ground to pursue in the Employment Relations Authority or Employment Court. But again, if the issue of concern does directly relate to a breach of an employment obligation, whether that be an unjustified dismissal, unjustified disadvantage, a breach of contract, you're more likely than not to get pushed in that direction by the Office of the Privacy Commissioner, if not by the HRRT. I've put quicker with a question mark next to it. Theoretically, matters that are filed in the Employment Relations Authority and go through that part should be resolved quicker. It's interesting, relatively recent amendments to the Employment Relations Act, for example, require authority members to release a written decision on matters they've heard within 3 months of it being heard, unless special circumstances exist. So you could argue that if you want a quicker outcome, you can pursue that. Of course, the other aspect to bear in mind is that the Employment Relations Authority and Employment Court deal with interim orders fairly regularly. They are pretty well geared up to deliver justice where interim orders are required. So that can be an important factor to bear in mind. The money that's involved, well, look, despite Judge Ingalls' comments, from what we see, the amounts of money being awarded in the Employment Relations Authority is not massively rising up. You were still looking at those sort of average figures that we see up there in the slide. Generally 3 months lost wages if you can demonstrate a loss. Generally the compensatory payments are still in those sort of lower levels, but I think we are seeing anecdotally at least a small increase in that area. If we go down the employment realm, we're having to formulate our claims very much around the matters that are set out in Section 103 of the Employment Relations Act. The other thing to bear in mind is costs. maybe it's my own personal view, but I don't get the sense that the employment jurisdiction is one that is amenable to the layperson successfully navigating necessarily. That's my own personal opinion. I think it's become more of a relatively legally technical area to get involved with. And there are plenty of good advocates out there and representatives. It's not just a legal aspect of things, but understanding how it works does get you a long way in terms of getting effective outcomes in there. So those are the aspects. It is important to be aware of the relative pros and cons of the two jurisdictions when you're representing clients. So recruitment. As I said, look, recruitment just keeps coming up again and again as an issue. We see all sorts of interesting issues. And it does surprise me. We deal with a lot of HR practitioners in this area. And, yeah, sometimes the level of understanding and the ability to apply the Privacy Act and the privacy principles is a bit wanting. So it was quite nice to hear that the Office of the Privacy Commissioner is putting together these modules on employment. I think that could be a really fantastic thing. I know half a dozen people I'd love to get straight away onto learning about the application of the Privacy Act in employment scenarios. But look, one of the areas that we see time and time again is around recruitment, and in particular around the collection of information. We do see employers from time to time who do stretch the limits as to what they're asking. And I think it comes back to this, the first two sort of bullet points there. You know, thinking back, why am I asking for this information? What's the lawful purpose that I'm requesting this information in the context of recruiting for this particular role? Every time we see something going wrong, there's been that failure to ask, why am I collecting this in the first instance? And when the person's unable to give you a coherent answer, you can tell you've generally got a problem. Likewise, is the means and the method of how I'm gathering this information, is it unfair or does it intrude unreasonably? And I've mentioned quite an interesting little case note from the OPC's website. I mean, again, ringing up a referee and then asking that referee, hey, can you tell me about this applicant's relationship between his wife and his children? What's that got to do with anything? Quite remarkable that these sort of things still go on. What we often see, and it's the crossover as well with the human rights jurisdiction, is that people asking questions and seeking information that potentially looks like there is an intention to discriminate on one of the prohibited grounds of discrimination in the Human Rights Act. Again, that comes up more often than you would hope to happen. Often those cases in the employment regime tend to be around age or disability, the two grounds that we tend to see questions perhaps inappropriately posed, or again posed without thinking through the legalities of them. Fairly common still for a lot of employers to request criminal record information from employees. Most of people will be aware of the criminal records, the Clean Slate Act, as it's aptly named. It's been around long enough that you would expect that most HR practitioners are aware of it and aware of the obligations to not ask questions that could involve a breach of that particular legislation. That is in and of itself is an offence. The last bullet point there about the Vulnerable Children Act is something that's relatively new, and I know a number of employers are struggling with the implementation of this legislation and the privacy aspects around it. The legislation, of course, requiring for certain occupations mandatory police checks into their current employees and, of course, their prospective employees. So these are some of the particular areas that we see arising on a relatively regular basis. Referees. Just another great area for fascinating aspects of things. Again, I suspect it's a fundamental sort of misunderstanding or difficulty in applying the principles to the practicalities of contacting referees. Who can I actually contact? That one comes up again and again in our perspective. What do you mean I just can't call whoever I want to talk about this stuff? Can't we just access the old boys or the old girls network and find out about this person? Well, if you get caught, there's likely to be consequences of this. Again, the Privacy Act is relatively clear on this front. If we're going to collect personal information, well, we should be trying to collect it from the person concerned in the first instance, unless one of the exceptions apply. If we're looking for referee checking, well, we need the person's authorisation. And it is that high level, it is that informed consent that we're talking about there. Not, oh, I ticked a thing online and, next thing you know, you're speaking to everyone who's ever employed me. There is an element required under the Privacy Act of explaining to people what their information is going to be useful, explaining to them what happens if they choose not to give you that authorisation or access. Again, it's fascinating that these things do come up so often, but they do. And I think the last case that's mentioned in the last note is one that, again, I mean, we've had ministers of the Crown who've not quite understood the concept of informed consent in a privacy transcript. So maybe it's not that surprising that employers still struggle with these elements of things. As Susan mentioned, obviously. Technology is a big thing. We do see a greater reliance on employers wanting to check social media accounts for people in a recruitment context. Again, but without thinking about these fundamental starting points. Why am I collecting this information? What's the lawful purpose that I need access to this information for? And is it publicly available? That Baywide case that I referred to earlier is a disturbing element in that case, where involving managers in a workplace standing over a younger, more junior employee demanding access to their Facebook so they could see the picture of the cake involved. Now, I've never heard of any incidences of that sort of thing happening in a recruitment context in New Zealand. Certainly, I've heard about it anecdotally overseas. Of people being told, if you want to come and work for us. You change all your settings on your Facebook, and we'll have a good old trawl through there. Again, I've never heard of it happening here, but again, employers need to be thinking long and hard before they do such things. Medical information. Again, in my view, this maybe 10, 15 years ago in this jurisdiction, we had employers running rampant in this particular area, demanding all sorts of weird and wonderful things of people. I want your entire ACC records. I want every record of every claim you've ever made. I want our company doctor to see every sort of medical record that's held by your GP about you ever. Deeply intrusive and arguably sort of unfair attempts to access employees' personal information. When there's often really little, no reason that's legitimate to do so. I must say, I think employers on the whole have generally got a little bit smarter in this area. I mean, there's been a few sort of more high-profile cases. That Imperial Enterprises case that's referred to there was an interesting one, and the employer got a fairly decent slap on the hand for asking inappropriate questions and trying to rely on that information. But I mean, if you do see obviously employers who are still asking questions like that one I put up there in italics, do you have any medical problems of any time? They're clearly overstepping the lines, whether on a privacy basis, whether on an employment law basis. I think there's a degree of agreement between the two there. Credit information, again, it may have been covered by others in other subject areas, but you do get employers who are still not aware of the Credit Reporting Privacy Code and the requirement that if you're going to conduct credit checking of a potential client, there must be a significant financial risk opposed to that. Now, I suspect that the significant financial risk will be in part determined by the nature of the employer and the nature of the employee's role and tasks. I suspect it's going to be a relatively objective view of that. But it is something that you speak to employers about, and they have this in their pre-employment checking. They're not aware of the code. They're not aware that they actually have to justify these aspects in this regard. So it's another area that does come up from time to time. Disclosing information about employees, well, yeah, it's my experience, and probably that's more dependent on the basis of who our clientele are. We get a lot of people in the public sector wanting to see information about themselves when they've applied for a job, whether they've been successful or not. We seem to see a lot of privacy requests around that. And again, there's issues around this question of evaluative material. Section 29 of the Privacy Act allows an employer, an agency, to potentially withhold evaluative material. And again, you see issues that arise from time to time around that. And I'll talk about the types of information in a second. One of the issues that often comes up is intra-agency references. You know, this person already works for us. Can't I just rush off and go speak to their current boss, you know, and find out all sorts of information about them? Well, the answer is possibly not. You know, it's probably going to be no. Is that the reason why the organisation has collected that information? Has the person authorised it? You know, there's a number of interesting questions and issues that arise in there. My advice to employers, you know, intensely practical as it is that if you're in doubt, get the candidate's approval, even if it's within the same agency, even if the information is in the same place. Better to play safe, better to be transparent in the way that we operate. It serves a number of purposes, not least only avoiding sort of complaints to the Office of the Privacy Commissioner. If the person says no, well, you know, as long as we're clear what the consequences of that are, then, you know, look, potentially we're okay around these aspects of things. The point I want to touch on is this last point. You do get employers from time to time who want to rely on the exclusion for evaluative material in the Privacy Act in processes such as disciplinary processes, structures, or redundancies. Because the employment jurisdiction is obviously a different jurisdiction, that may not actually hold up. In fact, it's unlikely to hold up in those situations when you are looking at potentially ending someone's employment because of Section 41AC of the Employment Relations Act. Susan will talk about that in a second. Look, lastly, in terms of evaluative material, what sort of things are we talking about? These are the sort of things here: referee information, psychometric testing. And if you're looking as a practitioner, where's a good place to go? Where's a good decision to have a look at about this evaluative material? The case that I've referred to there, the New Zealand Institute of Chartered Accountants, is a good place to look. It's a good, nice decision in terms of looking at what do those principles mean and how can I apply them. And the last bit is obviously just a clear bit of advice for practitioners in this area. You know, if in doubt, make sure you've got informed consent for people. Make sure you keep a record of getting that informed consent. I mean, most places have very good systems for capturing those sorts of things, but if in doubt, if you're just doing it verbally, you know, it is important to keep a record. Right. Drug testing. Look, I think this is an area, I mean, in the employment jurisdiction, we've probably had a good sort of 10, coming up 15 years of running with these cases about drugs and alcohol and how that impacts in here. Where I suppose we haven't seen a lot of notice or attention as of yet, I think it is in the privacy realm, how this stuff actually fits into the privacy regime. When do we see drug testing in employment environments? Generally, you would see it often in primary industries, forestry in particular, the likes of Air New Zealand, which is the case I've referenced there. You see it in a variety of often quite safety-sensitive industries. The types of testing, you know, that you might see there: pre-employment, reasonable cause, so, you know, where someone looks or appears to be intoxicated. Post-incident accident, those are relatively common in a variety of organisations, and random testing. Again, that case that I've cited there is probably the key case in the employment jurisdiction for standing for this type of testing for drugs and alcohol in working environments is legitimate and justified on health and safety grounds. Of course, it's the pre-employment one is quite interesting. I think there's a reasonable argument that some employers use pre-employment drug and alcohol testing relatively oppressively in this respect. And if you're not in an employment relationship, the reality is if you've got a complaint, if you've got an issue, it's either a privacy complaint or it's going to be a human rights complaint, because no employment relationships ever existed. That's the reason why no employment relationship was ever formed, because you failed one of these tests. So I think given the growing prevalence of pre-employment drug and alcohol testing, I see that in an area where the privacy jurisdiction will probably look at. The methodology is another interesting thing around privacy. The commonly accepted way of testing for drugs is urinalysis, which is quite an invasive means of testing. In Australia in particular, they've adopted a scientific standard for oral swab testing, which is, the sort of take a swab from inside of your mouth and it's tested there and then. It's an interesting question. I mean, if we're supposed to be gathering personal information in the fair and probably least intrusive manner, I can tell you which one I think looks like the least intrusive manner of drug testing. When testing occurs is quite an interesting thing too. I was talking to a colleague last week and he was saying, I've got a client in the Wairarapa. They said that the drug van, sounds rather interesting, pulls up out the front and everybody gets trooped out who's been selected for a test in front of all their colleagues, and then if someone's taking time to produce a sample, shall we say, the health and safety person was banging on the door of the van to get him to hurry up. I thought, I see some privacy issues. Maybe I'm looking too hard, I don't know. But it's really interesting. You see the sort of areas of things. The nature of the testing, the means, the circumstances of the testing may all be legal from an employment perspective, but they potentially raise issues from a privacy perspective. And I think they could be pursued potentially in either jurisdiction. The last point I want to make on this is the access and use of this information. Again, I see a lot of employers sometimes struggle with those concepts. Who should actually see this? How long should I keep it for? Who should I actually show it to? And what do I use it for? Again, these are areas I think that there's an opportunity, I think, as practitioners, unions, advocates and representatives start looking at that to look into those a bit closer with a privacy lens on them. At this point, I'm going to turn over to Susan, and she's going to talk to you about good stuff, discipline.
Thanks, Blair. I'm talking about disciplinary processes and covert surveillance, some of those issues. So, firstly, recordings of meetings. Certainly my experience is that it's becoming increasingly common to actually tape record. Sorry, my language is probably a little historic. What do you call digitally record meetings rather than take notes at disciplinary meetings. And I think there are a number of reasons for this. One of them is because the Employment Relations Authority keeps setting the bar higher and higher in terms of the level of analysis that needs to be undertaken of evidence when you are undertaking disciplinary action. So because of that level of specificity and the need to get it right, and because it's in some ways easier, we're seeing more and more people take recording meetings. Couple of things there. That's not a breach of privacy, because if the other party knows that you're doing that, you're not going to be breaching the Privacy Act, nor are you going to be breaching the Crimes Act, as I will get onto in a minute. The only possible issue there is whether an employee feels in some way intimidated because you've got a tape recorder in the middle of the table. Look, my view of that is, unless there are sort of particular circumstances such that the person is particularly vulnerable, may not be represented, generally it would be fine to proceed with tape recording a meeting. There's also great agencies out there who transcribe these things and are remarkably efficient and really accurate. So rather than sitting there trying to take notes and ask questions at the same time, I'm certainly increasingly transcribing and tape recording those meetings. So where do you draw the line in terms of some of these things? Covert recordings are another issue, of course. That is where the other party does not know that you're actually doing this. So one thing you need to be aware of is Section 216B of the Crimes Act, and that talks about intercepting communications. So an interception device is a device which literally records communications. And what that section basically says is that it's a crime to record somebody if you're not a party to the discussion and you don't know that it's being recorded. But then conversely,
it's not a crime in the event that you are a party to the discussion, and of course the other person doesn't necessarily need to know you are recording them. I'll get on to how that works in practice in a minute. The other interesting thing is that the Employment Relations Authority doesn't really care whether it's legal or not, a bit like the National Party in terms of its use of music. But what the Employment Relations Authority has is the Section 160, which basically says that it will decide in equity and in good conscience what evidence to take into account in any case, whether it's strictly legal or not. That's actually what the Employment Relations Act says. It's quite funny, isn't it? You know, we'll take into account any evidence we see fit, even if it's basically illegally obtained. So that's the Employment Relations Authority for you. So how does that work? Let me give you a case example. Firstly, the Bosman case here, that was an example where the employee secretly recorded a discussion with their manager. Now, if you think back to the Crimes Act that I've just told you about, if you're a part of the discussion yourself, it's not illegal, even if the other person doesn't know that you're recording it. So that's number one. Then the other party argued that the recording had been doctored, to which the authority said, well, that's fine, we can actually hear evidence about that and cross-examine the party as to the accuracy of it. So they let that in. It's interesting. The next case there is quite useful too. There were basically 3 different communications at issue in that case. The first one was where the employee recorded their manager in a discussion that they had with them. The manager did not know they were being recorded, but because they were both parties to the discussion, it was not a breach of the Crimes Act, and it was admissible in terms of the Employment Relations Authority. The second discussion was the employee basically taking their cell phone and leaving it in an area where they knew that the colleagues were having a chat in order to try and pick up some of that chat which they thought was bullying in relation to them. So basically they were trying to collect evidence of other people talking about them to support their claim for bullying. Do you think that got in? Is it a breach of the Crimes Act? Yes, because I'm not a party to the discussion, but the authority, as I said, is not particularly worried about whether it's a breach of the Crimes Act or not. They let that in equity and in good conscience. And part of the rationale there was that there was actually other evidence of bullying in this particular case, and this was just part of that whole picture. Now, the third one was basically an inadvertent tape recording. Now, the employee said it was inadvertent, but I'm not sure how inadvertent it was, but basically the cell phone just happened to pick up a discussion. Now, the authority did draw the line at that, basically because it wasn't clear even who the parties were, when it was recorded, what the purpose was, etc. But you can see from that case that the authority takes a fairly liberal view in relation to what it's going to consider in evidence, irrespective of whether or not it could actually be a breach of the Crimes Act. So surveillance at work, I think the key thing to be aware of in this particular slide is the bottom bullet point, and that is your obligation to inform employees of information being collected. And information is collected in all sorts of ways. You've got your obvious things like your email, your text messages, but what about GPS that records where people happen to be travelling? I've had a case relatively recently of a video camera set up in the atrium area that happened to be recording people coming and going from the building, what that can be used for. Of course, you've got swipe card access. You're collecting information about your employees all of the time, and in order to be able to use that information, you need to think about whether you have policies in place that tell employees that you are collecting this information, and then secondly, what it can be used for. Now, the what it can be used for bit is interesting because you might be collecting information for a particular reason. For example, you might have a GPS in the car for safety and security and to help the person get to where they need to get to purposes. But can you then turn around and use that in a disciplinary setting as evidence that the person is not where they say they are or should be? Well, I tell you, your chances of being able to use it are a heck of a lot higher if you have a policy that says we do collect this information and we reserve the right to use it in connection with a disciplinary scenario. Likewise, in that case I described just before about the video camera set up looking at who's coming and going from the building, actually it's there primarily for security purposes, but there was no reason in particular that the employer couldn't use it as evidence of whether or not the employee was at work when they said they were at work. So if you are wanting to extend the use of information, it would really help to have a policy in place that actually says what you're going to do with it and what you can do with it. This is quite a good example of where the line is drawn. So here we have an employer who said, we need to search people's bags because we've got a number of concerns. One is that from a health and safety perspective, we're concerned about shotguns coming into work and bombs, I'm not sure what sort of employer this was, and drugs. So there are a number of health and safety and security concerns, and then they were also concerned that there were thefts, and that from the perspective of company property, personal property, they needed to check the bags. Now, firstly, the Privacy Commissioner looked at this in this case note and said, well, that is a related purpose. You don't necessarily collect the information for that purpose, but it is sufficiently related to the purpose of collection that that would be acceptable, provided it intrudes on the person's privacy in the least possible way. So you see where they drew the line is at handbags. And there's a reason for that, because the employer was claiming that relatively large items were going out of the workplace, larger than one could shove generally into a handbag. And secondly, of course, handbags are generally more personal, so that was what the balance was. So the outcome of that case was that the employer was entitled to have a policy providing that it would look at bags and boots of cars on the way in and out of work. Having said that, it can't just do that. There is still an issue of consent, because this is, of course, the person's own personal property. So it still required employee consent, but also said, in the event that employees don't consent, well, we can draw an adverse inference or possibly even call the police. So that was quite interesting. Email and internet surveillance. I think most employers are reasonably comfortable with this these days, namely that if you provide computer facilities to your staff, then that's basically your equipment, and you can go back and look at the emails, you can go back and look at the internet usage, and that's all part of what employees sign up for. But again, it would be extremely useful and important to have a policy that actually sets that out, and the fact that the employer can do a sweep in the event that they see that there is a good reason to do that. And the ANZ case that I've referred to up there talks about that, where firstly, the reason that the employer did the sweep of employees' email and internet usage was to pick up potential porn or inappropriate usage. The court said, well, that's fair enough. This employer has an interest in ensuring that there's no illegal activity going on its computer network, so there's no reason you can't undertake an audit of that nature. And then secondly, the employer did have policies that the employees had signed up to, which actually enabled the employer to undertake searches of that nature. So, two things that the employer did right. One was have a policy, and then two, exercise an interest, a legitimate interest that it had in ensuring, for example, the harmful digital communications legislation wasn't being breached. So, I guess point here being that whilst your purpose for looking at information must be connected with the reason for collecting it. The general employment context, including ensuring compliance with policies and procedures, will generally fall within that. Covert surveillance in terms of video monitoring and so on, this is always sort of a slightly awkward one, and we do get employers calling us up sort of feeling slightly uncomfortable about this, and for good reason. But the bottom case note is quite interesting. So it involved a case where there had been thefts from a particular locker in a dressing room, and the employer set up a video trained specifically on that locker, and it was motion activated. And the Privacy Commissioner looked at a complaint about that brought by the union and said, actually, look, there was good reason to set that up because there had been thefts from this particular locker. Secondly, it was as unintrusive as possible. It didn't focus on, for example, the toilets, the showers. It was only on this particular locker. It was only motion activated around it, and it was there for the shortest period of time possible to actually achieve the outcome required. So, it doesn't get that much more personal than that. And if you look at that particular case, setting up, for example, a video camera above a till or in the open workplace or anything of that nature, if there was a good reason to, would almost certainly be acceptable. Does that go further than you would have thought in terms of comfort levels? A video camera in a locker room? I mean, I guess it does probably come down to the employer's need to do that. And had, for example, the employer just done it randomly, in case there were things going missing from the locker room, then I don't think you would have got the same outcome there.
Is it relevant whether there's sort of audio as well as visual happening? Is that relevant? If we're trying to ID it, I would assume you just need the visual, and you wouldn't need to pick up conversations within the vicinity of the camera.
Yeah, so it's a good question. If you took that back to the Crimes Act scenario of picking up audio of people where you're not a party to the discussion and they don't know that you're doing it, then it would likely be a breach of the Crimes Act. That doesn't necessarily mean it's a interference with privacy, but I think it would be far more likely to be viewed that way. I think the other way to look at it is, what is the minimum amount of intrusiveness that we need to in order to collect the information required? And as you've pointed out, you probably don't need the audio. Just briefly touching on another, before we move on in terms of covert surveillance or surveillance, are there any other questions? Otherwise, there's just one brief slide. Hi.
Hi, on the subject of being a party to the communications, if you don't want to use that information, say, to play back to a colleague in your recruitment deliberations or whatever, how is that set with the Crimes Act?
So probably two different questions. Firstly, is it a crime to collect the information in the way you did? If you're party to the discussion, no, it's not a crime. And that's all that the Crimes Act is interested in. From a privacy perspective, it's a different question because you've collected the information for a particular purpose. Then your usage of the information must be consistent with that purpose or a directly related purpose. So if you did that because you wanted to collect it for the purposes of a recruitment discussion, then it would be consistent with that to do so. In fact, most employees in that context collect information because actually they want to use it as evidence that their employer has treated them badly. And I've certainly been in the Employment Relations Authority where all of a sudden the employee jumps up with their cell phone and says, well, what you're telling me is not the truth because here we go, we've recorded it. That's unhelpful for the employer at that time. So, but it's not unlawful. And then the authority will, of course, assess whether or not it's admissible.
Excuse me. Sorry, quick question. So regarding that locker room scenario, it'd be pretty difficult to sort of not capture, people walking past it. What if it was a kind of locker room where you've got people sort of getting changed and things like that? I mean, how do you
issue?
Yeah, look, I think every case is going to have to be determined on its merits. From that case, no, I don't know whether there were people sort of parading in front of the camera. I mean, presumably so if it was a locker room, but I guess it comes down to a question of, does the employer's need to do this outweigh the possible interference of privacy of the people? So, you know, what the employer did was everything it could in that circumstance to limit that. And the Commissioner said in that particular situation it was acceptable. But you know, if it was the type of locker room where people are parading around with no clothes on and you're capturing all of that, then it may well have been different. Just moving briefly on to a couple of issues I wanted to highlight before we finish up. One relates to restructuring and the case that Blair referred to at the beginning of his presentation. So what you have in the Employment Relations Act is Section 4 that says in any case where an employee's employment could be adversely affected, so the continuation of the employment could be adversely affected, in short, the person could be fired. In any circumstance like that, they're entitled to all relevant information and the opportunity to comment on it. Okay, so that's the first thing. Now, that was interpreted in the Massey case very, very broadly. So Massey case basically, lecturers at Massey University are disestablished, less jobs than there were before, so they all had to apply for the remaining jobs. 2 of them were not appointed. They complained that they should have been entitled to see the interview notes and the grading of the people who were successfully appointed. And the court looked at that and looked at Section 4 and said, well, yes, in fact, that is relevant information because they need to be able to compare how they did to the successful candidates, and therefore it was required that the employer give them this information. The court, of course, considered the Privacy Act implications, and I would say there were quite significant Privacy Act implications when you start dishing out interview notes and scoring of other candidates, but was not moved by that, still said Section 4 overrides all that, that's relevant information and you need to provide it. And what's more, you need to provide information that is in the minds of the interviewers. In other words, the interviewers had to retrospectively write down their assessment and thoughts about all of the candidates and hand that over to. So how much do we like that? Do you know what? Following that case, people didn't take notes. That's exactly what happened. Everybody looked at every possible way in which to avoid the implications of that case. And there are not too many employers that I'm aware of who ever complied with that. We all sat there waiting for the law to change, and it did. It did relatively shortly thereafter because there was a furore. So they then introduced this section which says, Section 4, except where it would involve the unwarranted disclosure of information about the affairs of another individual. So that basically set the balance back where I think it should have been before the Massey case. So long story short there, in any situation where somebody is at risk of losing their job, you do have to give them a lot of information, all relevant information, but not information about another identifiable individual that is personal to them. That's where the line is drawn.
In a town as small as this, a lot of that is just nonsense and all that. People talk to each other all the time about people intending to employ them on their short lists. You know, just have little chats about people.
I don't know what to say about that. Well, it might well be true. Right, moving on. So, just the last topic briefly to refer to is usage and retention of information. So, firstly, what you can use information for, and I've put up 2 examples to demonstrate where the line might be drawn. Now, the first one is, all right, you collect employees' bank account details. Why? So you can pay them, right? That is the purpose for collection. Now, if you think that employees within your organisation might be basically pilfering money, can you have a sweep of the bank accounts to see whether there's any match between the account that they've paid their wages into and the account to which some of the stolen money is flowing. Can we do a general audit just to see if we can find a match? No? Okay, I think we're all agreed with that a general audit in the absence of a very good reason not to would be going too far. But what about where we suspect a particular employee? Good grounds to suspect a particular employee. Could we do it then? Why? What's the difference?
Provision in the principle, isn't it? Investigation of a crime.
Yeah. I mean, look, in the event that there is a particular reason to do it, because you have fairly tangible evidence, I would have thought, in the situation, you may be able to do that. The other thing is for public sector employees, there is an exception in Principle 10 which talks about protecting the public revenue. So, a la our friend from the Ministry of Transport, they may have been able to rely on that section in order to say, well, actually, we have good grounds for believing there is something askew here. In order to protect the public revenue, we are going to have a look at your particular bank account. Next bullet point, really interesting one. Let me give you a scenario. Okay, so the police are out there doing their thing under the Land Transport Act. There is an accident, they take a blood sample. The person they take the blood sample from happens to be one of their own employees. Can they then use the results of that blood sample in a subsequent employment investigation? No, surely not. Completely unrelated. You've collected information under the Land Transport Act using particular powers that you have in that context, which relates to traffic and motor vehicle safety and the enforcement of crimes and all of that, compared to over here, the employment relationship being completely different. So, I would certainly argue, and I am arguing quite vigorously at the moment, actually, a case of this nature, that actually the purposes are too different such that you can't actually use that obtained in the employment context. Question?
Yeah, you could use it though, if, say the person was intoxicated and then subsequently charged. You could rely on the fact that they were charged, so you wouldn't actually directly be relying on the blood.
Yeah, okay, so really good point. Okay, so I agree with you in the sense that you wouldn't be relying on the blood sample, you'd be relying on the fact that the officer had been charged with a criminal offence, which then leads to an argument that that brings the police into disrepute, etc. But in this instance, there was no crime, the person wasn't charged with anything, so there was nothing other than the outcome of the blood test. Yeah. Question? Yeah.
Yeah, I was to say, if they're charged, I assume you have to rely on the fact that no name suppression was involved as well.
Yeah, well, the name suppression would be another factor in terms of what the impact on the employer would be in the event that that did become public. But, by that stage, we're not using the information that was collected over here, which was the blood sample. We're now on to something different, which is the fact of being charged and the fallout from that, namely the publicity. Yeah. I best move on just finally to mention the storage and maintenance of information. Obviously, you should only maintain or keep information for as long as strictly necessary based on the purpose. Just a note to remember the Public Records Act, which for public sector employers basically means that you have to keep public records almost indefinitely, but that Act does have a number of schedules which sets out different time periods for different pieces of information, including HR related information, which I believe is 7 years for information falling within that definition. So just something to be aware of there. So that was Cook's tour fairly quickly of the Privacy Act. Are there any final questions just before we wrap up?
Just on that one, the Public Records Act, etc., and criminal records. So, if staff have submitted criminal records as part of recruitment, what's your expectation of how long it should be retained for?
That will possibly, if they have provided that information, and they might not have to provide that information because of the Clean Slate Act, but if they do give you that information because it falls outside of what's protected by that Act, then I would keep it as part of their employment record for as long as they're employed, because it may well be relevant to something down the track. I mean, it would sit on their personnel file. I mean, what I would be talking about in terms of getting rid of information would be recruitment information where somebody is not successful in being appointed, except where you have that box which is, would you like us to retain this information in the event that you wish to reapply or be considered for something in the future. All right, well, thank you so much, guys. We've really enjoyed the discussion and particularly your engagement, so appreciate that. And
I just want to thank both Susan and Blair very much for coming along and sharing their insights and thoughts today and sharing the privacy and employment vibe with us. It's been really valuable. Lots of food for thought.